Welcome, everybody, to the Kiosk Presents. I'm Don Hoffman, and this segment is called The Law in Focus. And we're here today with attorney Jim Vallone. Jim, welcome to The Law in Focus.
Thank you, Don.
And welcome to the Kiosk Presents.
Thank
now,
you.
Listen, I know a lot of people, and I asked them because I recently had a will done. And I say, do you have a will? I got to tell you, more than half the people I ask say, no, what do I need a will for? So, Jim, would you please tell everybody why it's important to have a will?
Well, first of all, if you don't have that document in place, the state will dictate how your assets are settled. And of course, most people don't want the state telling them anything, not to mention how they have raised monies and assets, and how particularly they want those assets to be distributed. So a will does that, first of all. Secondarily, a will determine what person is appointed as the fiduciary to make sure that your intentions are carried out, and I think that's very important. And then the other reasons are, if you have young children, they can establish guardianships and trusts on behalf of these little tiny tots that you're taking care of and care very much about, and want to make sure that the right people are in the right places to make those decisions on behalf of your children and other beneficiaries.
Forgive me, I was so tempted to interrupt you. The state makes decisions about my money, my property, my children, if I don't have a will?
Well, they call that intestacy. What that means is that the statute, the New York State statutes, will serve as the arbiter, for lack of a better term, as to how your assets are distributed, as opposed to a will situation when you specifically say, I want this asset to go to this person, or I want this series of assets to go to these series of individuals. So it's always better to have the person decide through a will than the state to decide through their statute.
And what's that word, intestate? Meaning there's no last will and testimony.
Right.
So let me ask you a question, and not to bring up figures, but I would assume there's more legal costs if you die without a will than if you die with a will. Is that a fair statement?
Well, I think what's really fair is that if you don't have an attorney-crafted will, there's much more an opportunity to have it challenged. If you don't have a will at all, of course, you're looking at even more of an opportunity to do that. So why get into that? Whether or not you have a certain amount of assets, or whether or not you want to establish a guardianship for your children or a trust for your children, it's all good to have an experienced real estate attorney to draft the documents, and just as importantly, to witness the documents. Because when an attorney testifies, if the will gets challenged, you want an attorney to be the person that's on the witness stand as opposed to your friend or your neighbor.
Okay, final word on the matter. Is it smart for everybody to have a will?
No question.
Okay, great. Thank you so much for joining us today, Jim. And this is The Law in Focus.
Thank you.